talk about FER 901 and what it says. Okay? To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce sufficient to support the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. And specifically, in traffic cases and recording traffic cases, as you can see, the prosecution must prove that the citation accurately reflects an observed offense, which he's going to say that when he writes you the citation. It's issued by a qualified or credible witness. Has to be issued by an on-duty officer in proper jurisdiction. The method used to observe the offense must be valid and properly applied and written upon the citation. If it is not, then there is not a proper citation. The defendant, you, was a person actually involved in the matter before the court. Which means, and I say matter because you don't want to recognize the citation. You don't want to recognize any part of it when you're talking. You want to call it a matter. A matter. Don't even recognize it. Don't even say citation. Say, Your Honor, the matter before the court has been issued. My thing is looking for proper defenses as a pro se litigant, so that way you don't need a lawyer to defend yourself in traffic cases. They should be simple enough for a layman. Unfortunately, they do a lot. We change the language so that you cannot understand anything and you must spend money, because it is a racket. It's all about money, and there's no doubt about that. When you're studying a citation, look for any inconsistencies, any issues, anything missing. Look at the codes and the statutes. That's the first thing you should always do, is look up the code and statute that's placed on the piece of paper, on the document, so that way you understand exactly what the code says. Okay? But then you need to start looking for if every box is correctly filled out. Look for ambiguous details, like vague statute number. Maybe there's a lot of subsets to a statute that allow that statute to be cited for. And they don't list that subsection. How do you know exactly why you were cited? What's the specific performance required? And that's a big thing, is they don't always give you enough information. And how can you constitutionally form a proper defense if you don't have enough information? Does it clearly identify your vehicle? Is it your stuff? Make sure that's filled out. Does it have the speed, location, date, badge number? You have to look over the document. Is it proper? If it's not proper, I cannot administratively and procedurally proceed forward. When you're in court and as a lay person, and you go up and you look at this document and you're like, man, there's nothing up here that I can use. Say the citation, everything's filled out correct, but it's missing whether you were captured by LiDAR, radar, or presumed guesstimation, okay, or pacing. All right, say none of that's up there. How can you form a defense if you don't know what you're trying to defend yourself from? Okay, so you can use something like objection, lack of authentication under FER 901. The citation lacks sufficient information to be admitted as evidence that I committed a violation. It has not been shown to be what the prosecution claims it is. It's simple enough. It's a simple enough statement that allows you to challenge it. If you don't challenge it, nothing's gonna happen. You have to rebuttal. You have to open your mouth and say, hey, there's not enough information up here for me to form a proper defense to stand in front of this court, and that's unconstitutional, no matter where I'm at. And you have to stand on that. Say the officer's not present, right? Or maybe the prosecution attempts to admit the citation without the officer being there, okay? It's just scenario. Your Honor, your testimony, without testimony from the citing officer to authenticate the citation, there is no foundation for this document. Under FER 901, it has not been properly authenticated. Even if the officer is present, ask whether they recall the stop. Cross-examine the police officer at every turn. They're going to ask you how you plead, and then they're going to listen to him or the attorney push forth what's on the citation. Then they're going to interview the cop and have him testify to swear under oath that what's on that citation is true. If it's missing proper information, you should have already filed for a motion for dismissal. But it is very smart of you to pay attention to what's written on that citation. Say that citation does not have LiDAR, radar, or pacing, or guessed an estimation. It just says that you were traveling at this speed on this road and you were cited for this statute. Okay? Well, that's cool. When he goes to give his testimony, he's going to put that in there, and you need to object to that. That is late testimony, is late evidence, and you need to object to it, to late discovery, and ask that it be removed from testimony, that it cannot be used against you. If the documents are vague, and 9 times out of 10 they are vague because they know most people are just going to pay it, or they're going to go get a lawyer, and the lawyer's going to giggle and charge them $250, $300, $500, whatever he charges them, and he's going to pay the cost of court and go fuck off, or he's going to pay the judge $100, let you cost of court, throw it out, dismiss it, whatever. I've been to court for doing 100 and a 55. Give the lawyer $1,200. Watched him pay the cop and the judge. Do it right out, no problem. $1,200 went right away. Told me I couldn't get a ticket for you, or I'd get full issues back on me, and then I would have serious issues. And I would have to face charges for reckless driving and this and that. And it's pretty funny how money works that way, ain't it? But as citizens, it's time that we take back and we start defending ourselves in a court of law. I'll be back. One moment. Alright, let's see here. Alright. Let me pull up. Lack of proper notice. Okay. That's what it was. Okay. Lack of proper notice. And I use Slim Jet. I use Yandex. I like it. But I did not want to do Okay, that's right. So, shoot, where am I? I'm in the wrong spot. Okay. See the objection. Okay. Okay, there we go. Alright. So, getting back on it. One of the main things that you need to remember is the information on that traffic citation is all he gets if you rebuttal and stop him from adding. The day of the trial, right out the gate, pointed out and asked to submit. You want to prepare your own motion to suppress testimony, information in the testimony on lack of prior notice, and you can if you don't file motions under discovery rules, you're not going to get it, okay? You should always file that the morning of the trial, so that way the officer has to leave that out if you can get it to go through. And frankly, I would write it as a motion to suppress testimony under discovery rules, and you'll have to look up specifically the state that you're in federal discovery rules. If you're already in court and you're sitting there looking at the citation, you notice that there's no information about LiDAR, and you hear the cop get on the stand and says, well, I pulled out my radar or LiDAR. You should automatically object and say, the objection, Your Honor. This is ambush testimony. Or objection, lack of prior notice. In reality, you should have a meaningful opportunity to defend yourself. If the citation is too vague to allow that, then you can argue, you can object to the testimony that it's unfair. They did not afford you that information prior to trial, and now they're trying to enter extra evidence, extra information into the testimony that will not give you a chance to defend yourself because it was not given to you during discovery because they failed to offer discovery. And you're going to get resistance no matter which way you go. I don't care what you do, you're going to get resistance from the court, and they're not going to like you whether you get a lawyer and fight them or you do it yourself. So you might as well just piss them off and do it yourself and ram a big old Ricky Rack at them. You know, let's see. Okay, that's that. You know, before trial, you should already have pressed some form of motion to get it dismissed, especially if you're arguing lack of foundation to prepare a proper defense. You need to have already filed a motion right out of the gate. You need to do that before pretrial, during pretrial, whatever. But not the day of the trial, unless you're trying to be an absolute hardball, and you're not going to win that way. Unless you Joe Schmoes can walk into a certain courts, and I can assure you, most courts are not going to tolerate that. You might get some,